So today's problem is based on the constitutional validity of Section 124A of the Penal Code, and the case arises out of a public interest litigation which was filed before the Honorable Supreme Court. However, today the mooters will only be arguing on the second issue of the moot problem, and each side will be speaking for a total of 6 minutes, and the timestamps will be maintained in the chat box. Today's mooters are Mr. Raman Saraf, who's the counsel for the petitioner, and Mr. Ruhan Shah, who's the counsel for the respondent. They both are fourth-year students of the 5-year law course here at GLC and are amongst the most novel and prolific mooters of college. Presiding over these proceedings is a two-judge bench comprising of Mr. Yash Shiralkar and Ms. Ketayan Mistry. They are again two of the most experienced and successful mooters from the GLC alumni. Yash Shiralkar is an associate at Shardul Amarchand Mangaldas & Co. and he also served as the General Secretary of the Moot Association in 2018. His team was ranked 4th globally at the Foreign Direct Investment Arbitration Moot, and he was also the global runners-up at the Frankfurt Investment Arbitration Moot 2021, and many more. Ketayan Mistry is also currently working as an associate at Shardul Amarchand Mangaldas. She has participated and achieved success in a number of national and international moots, including the William C. Wiss International Moot, the NLUO International Maritime Arbitration Moot, and even the Warsaw Arbitration Tournament. We are indeed grateful to you for being here with us this evening. And judges, with your permission, we can now begin with the Demonstration Moot 2023.
Sure, let's begin.
The petitioner, Aman, you can begin.
Am I audible?
You are.
May it please the bench, I am counsel P1, appearing on behalf of the petitioners in the present dispute. Before I begin, I would like to seek the permission of the bench to refer to it collectively as your lordships. Thank you. Would my lords prefer a summary of the facts of the case?
Yes, I think a short summary would be helpful.
Very well. The present writ petition under Article 32 of the Constitution of Scranton assails the constitutionality of Section 124A of the Scranton Penal Code. This challenge is in the backdrop of a spate of arbitrary arrests by the newly elected government of Scranton under PM Dwight Schrute in the past 2 years under this law, without any cogent reasoning given by the government for the same. Further, an amendment was introduced to Section 124A, introducing supposed safeguards to this law, which has completely failed to achieve its purpose and has in fact further facilitated misuse. Several instances of these malified arrests are exhibited in para 12 of the moot proposition, which I will address shortly. Moving on to my contentions, I will be dealing with these on 3 prongs. The first, Article 14 violations. The second, violations to Article 19, and that Section 124A does not constitute a reasonable restriction. And third, violation of Article 21. Coming to Article 14, it is my submission that the wordings of Section 124A of the Scranton Penal Code are inherently vague and ambiguous, and in fact facilitate arbitrary action by the government and leads to excessive misuse of the same. It is settled law in the judgment of Kartar Singh versus State of Punjab that the basic principle of legal jurisprudence is that an enactment is void for vagueness if its prohibitions are not clearly defined. And the Supreme Court in fact opined that law should give the ordinary person of intelligence what is prohibited. They should know what they can do, what they can't do. It is my submission that Section 124A has completely blurred boundaries and in fact leads to ambiguous guidelines. It uses the words such as disaffection, disloyalty, and feelings of enmity, which are purely subjective and can be utilized by the government in order for whatever means that they wish to achieve and whatever vested interest that they have. And therefore, a total accumulation of all this leads to the principle of equal protection of law being violated, as the government of Scranton can then arbitrarily assign whoever they want and detain them in order to achieve their vested interests. I will limit my arguments to Article 14 here because I would like to move on to Article 19 and distinguish. But if there are any queries which the judges have before I move on, I would gladly entertain them. Very well. Coming to the next prong, which is Article 19 and a violation of freedom of speech. It is my submission that Section 124A does not constitute a reasonable restriction to the same. Post Kedarnath Singh versus State of Bihar, the Constitution bench, which has held that Section 124A is in fact Constitution, and which I am sure my learned friend for the respondent will rely upon, there have been several judgments that in fact, transformed the scope of freedom of speech. And the Supreme Court in S. Rangarajan versus P. Jagjeevan Ram has in fact held that you can only arrest somebody for a violation of freedom of speech if what they said is in the nature of a spark in a powder keg. It has to constitute imminent violence or imminent action. Section 124 Scranton Penal Code completely ignores this aspect of it and gives the government wide-ranging powers for anything that they feel to be disloyalty or feelings of enmity. Their entire ambit of urgency is ignored. Even in Aru Bhuiya, it is said that violence is the most important factor to consider before arresting somebody for a penal violation of freedom of speech. Section 124 again just focuses on vague topics, and therefore the reasonable restrictions as held by Chintaman Rao that they cannot be excessive and they cannot be arbitrary are violated by Section 124A. In fact, it is my submission.
Counsel,
Yes.
just a question here. Under the explanation to Section 124 here, don't you think that reasonable restriction would be the category the data would basically be met when you request somebody who's at a superior level to give you a reasoned request for the FIR, or basically a reasoned FIR telling you exactly what went wrong?
Very well. I'm grateful for that question, and I would like to argue and answer it on two prongs. The first, this amendment, explanation 4, which really creates this entire concept of a written sanction or FIRs being filed by the Director General of Police, in my opinion, is absolutely redundant. The reason being that what this only permits is that the government goes ahead and gives whatever token reasoning that they want without any actual material. And as I would like to take my lords to para 13 of the Moot proposition, if my lords have it with me, it says that the government in each of these cases has given purely inadequate reasoning, and they have used token terms such as public interest, potential to incite violence, and things along these lines. There's been no detailed explanation. And purely, I see that my time has elapsed. If I could take around 2 minutes more in the interest of justice to continue.
Sure.
I'm grateful. So what really happens is the government puts these token violations forward, and then they say that you have to be detained, and they are detained even pending trial. So this is the nature of the explanation. Even the Director General of Police just has to give a written reason communication. But none of this is an actual safeguard when viewed from the fact that the government truly wants to go after somebody's vested interest. All they have to do is give a token term and then go ahead with it. Now coming to my next argument, which is that of Article 21. But before I say that, I would just like to caveat this by saying that Article 21 in this case would be the most pertinent, because what the government is doing is violating your right to live with dignity by branding you as a criminal based on their arbitrary whims and fancies. Firstly, coming to the aspect of proportionality, the Supreme Court in Puttaswamy has laid down 4 prongs, but the main aspect of it is that you have to use the least restrictive way forward. Now, the judgment of Kedarnath Singh had stated that in 1962, Section 124A had struck a correct balance between individual fundamental rights and interests of public order. However, that's not the case in today, and there are many more other less restrictive ways that we can address what the objective of Section 124 is. There are a number of other legislations that have been drafted, such as the National Security Act and the UAPA, that do have additional safeguards which are not like Section 124A, and therefore there are less restrictive means available.
Sorry, Counsel, sorry to interrupt you. Can you
Yes.
just shed light on what is the golden triangle test? Because that's what's the issue that we framed.
Completely. I'm grateful for that question, in fact. So in Maneka Gandhi versus Union of India, what really was the concept that was developed by the Supreme Court is a golden triangle test, which talks about Article 14, 19, and 21 and the interplay between these 3 articles. So basically, if 2 out of 3 which are directly connected with your right to life under Article 21 are violated, then the law must be struck down, because these 3 work in continuation with each other. They overlap each other to a large extent, and therefore it cannot be that it violates one article and can be upheld by another article. I see that my time has elapsed. If I could conclude my arguments.
Yes, please, in 1 minute maximum.
Thank you so much. So ultimately, coming to my last argument under Article 21 is the right to live with dignity. And again, in Maneka Gandhi, while opining on golden triangle test, they laid down certain procedural safeguards which said that the right to live with dignity is an inherent part of Article 21. And it states that blatantly being marked as some criminal cannot be a plausible way for you to live your life with dignity. And in my submission, Article 1, Section 124A does precisely that. It brands you as a criminal for life and then tells you to live in society with people who will view you with suspicion, an inherent violation of Article 21. And therefore, I conclude by saying that Section 124A of the Scranton Penal Code violates each and every of these three articles. So the Golden Triangle test has been completely demolished by the government in this case. Articles 14, 19, and 21 have all been violated by this section. And therefore, in light of the arguments advanced, issues raised, and authorities cited, I pray my lords to refer the question of constitutionality of Section 124A to a constitution bench of the Supreme Court in order to really assail the constitutionality and decide this issue. I'm grateful for a patient hearing.
Thank you, counsel.
Your lordships, am I audible?
Yes.
All right. May I begin?
Sure.
Sure. May it please the bench, I am Ruhan Shah, counsel for the respondent in the present case. Assuming, of course, that this writ petition is maintainable, which itself is an extremely dubious question, the contention at hand now is to check whether this particular article, that is Article 124A of the Constitution of Scranton, including all four of its explanations, satisfies the inherent golden triangle test of Article 14, 19, and 21 of the Constitution of Scranton. As mentioned by the counsel for the petitioner, through the landmark case of Maneka Gandhi versus Union of India, it was blatantly and completely settled that while these articles do operate in a consolidated manner, for any form of legislation to pass this test, it must stand the test of all three articles individually as well, considering the overlap that exists between them. Simply to provide a roadmap of my submissions here today, I will first be dealing with Article 19 of the Constitution, followed by Article 20, and lastly, Article 14 of the Constitution of Scranton. With reference to Article 19 of the Constitution, intrinsically what this does is give citizens of Scranton the right to freedom of speech and expression, which is an intrinsic part of the Constitution as a whole as well. Admittedly, however, these particular rights are not absolute and are in fact subject to reasonable restrictions. For instance, the security of the state and public order and any other such aspects that exist under Article 19 itself. Article 124A of the Constitution, which deals with the concept of sedition, is one, which is, of course, the article that is currently challenged, squarely falls within the ambit of the same reasonable restrictions as was established in the landmark judgment of Kedarnath Singh versus the state of Bihar, where a constitution bench, in fact, actually held this. The pertinent part of that particular judgment reads that criticism of public measures or government action would be consistent with the fundamental right of freedom of speech and expression. However, when such words written or spoken have the intention of creating public disorder or disturbance of the law must step in to prevent such activities in the interest of public order. Here, clearly, public order has been carved out with reference to such pernicious tendencies or creation of disorder and has been given as a reasonable restriction with reference to Kedarnath Singh. As such, even Article 124A, which uses terms such as incitement of violence or incitement of disaffection, clearly can be construed as sedition, and this is in line with the decision of the court. The petitioners have further contended, which is essentially my second submission.
Sorry,
that
counsel, I just wanted to stop you there. You said that certain terms in the provision, incitement to violence, incitement to disturbance, can be construed as sedition, but it also leaves, I guess, the government with a wide ambit to construe it in any manner that they want. And if that happens, that's effectively a violation of fundamental rights of the citizens that's happening. So would you suggest that such an interpretation is indeed not possible of 124A?
Submissions on Article 14 of the Constitution, considering the grounds raised by the petitioner here referring to vagueness, would squarely answer this particular question. With reference to Article 14, essentially no person is meant to be denied equality or subjected to unreasonableness by virtue of any vague or arbitrary reading of certain provisions. However, it is submitted to the claim of the petitioner here that there is some degree of inequality that creeps in by virtue of Section 124A is extremely untenable at two stages. Firstly, at the stage of the legislation itself, that is Article 124A, and as well as with reference to the executive action that may be taken under such legislation. Firstly, with reference to Article 124A itself, I would like to bring the attention of your lordships to paragraph 5 of this proposition, where 124A is actually reproduced. Here it is clarified, if your lordships are with me. Here it is clarified that terms such as disapprobation, which essentially talk about measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, these essential aspects are not considered as sedition and have been left outside the scope of sedition. As such, the scope of any sort of arbitrary action has been dealt with at the legislative stage. And in fact, in the case of Arup Bhuyan versus the state of Assam, there was a test which was initiated known as the Brandenburg test, which was established, which essentially sets the legal standard for what is construed as protected speech. And it essentially states that only speech, the speech that is protected by law essentially, is speech that would not cause imminent lawless action or is not likely to incite such action. Over here, only those particular actions that can be construed as violence and would incite such violence are what constitutes as sedition. And therefore, at the stage of legislation, I sense a question, Your Ladyship.
Counsel, however, here, by way of explanation one, it mentions that the expression disaffection includes disloyalty and feelings of enmity. These, as your opposing counsel pointed out, do not really define the term, and it would be very difficult for a layman, person who does not understand the law, to fathom whether or not he would be jailed for speaking something that would be on his mind or might be construed as disloyalty. In such a case, would this fall within a reasonable restriction?
Thank you for your question, Your Ladyship. 2 points to note in this particular regard. The first is, naturally, such a provision would, seeing that I have 1 minute left, if I could simply request an extension for a minute more afterwards. Thank you. With reference to this particular provision, explanation one essentially states a definition for the term disaffection. And while, of course, this definition is one that is broad in nature, it is submitted that that definition is one that is required to be broad in nature, considering the level and number of activities that could fall within its scope. However, additionally, the definition has been restricted to a certain degree, considering that it only limits itself to those particular things that would create disloyalty and feelings of enmity. As such, we do not believe that there would be any degree of vagueness that would creep in this particular regard. Additionally, there has also been a clarification issued by the Prime Minister of Scranton at the time, in the form of a press release, which essentially states that only those particular verdicts that would have the potential to incite violence and cause internal disturbances would be what would qualify as sedition under this particular section, Article 124. As such, clearly there has in fact been a clarification, and therefore any degree of vagueness would essentially not be applicable in the present case. Additionally, even at the stage of executive action, while the petitioner has painted a backdrop against these particular arrests that may have taken place, and while there may be some degree of arbitrary action with reference to the same, which of course can be discussed in a later proceeding, the fact of the matter is that in the landmark judgment of R.K. Dalmia versus Justice Tendulkar, it was held that where the statute lays down such principles, but the executive action fails to adhere to these principles, the executive action, but not the statute itself, should be condemned as unconstitutional. As such, presently, even if the petitioner would come today before your lordships and claim that these particular arrests of these individuals is arbitrary, is unreasonable, that itself would be insufficient to strike down this particular statute, that is 124A, as unconstitutional. With that, I rest my case if your lordships have no further questions. Much obliged. Thank you for a kind and patient hearing.
Thank you, Counsel.
Thank you, Counsel.
May I begin my rejoinder?
Sure, Counsel.
Thank you so much. There are 2-3 points which I must highlight, which in fact, I think my learned friend has done me a favor by arguing. Number 2, his reliance on explanation 2 of section 124A is inherently wrong, because explanation 2 in fact gives the kind of exclusion which they create states without exciting or attempting to excite hatred, contempt, or disaffection. And this term disaffection is the very term in explanation 1 with which we join issue and with which we say is the root of the problem. So merely by giving this token explanation 2 saying that you can criticize the government without spreading disaffection, but using the same term in explanation 1 would not solve the problem. Secondly, my learned friend stated that section 124A must be very broad to give the government wide amplitude. He said that is required. Over here, he could not have summarized the issue better and the concerns of the petitioner better today. It is well settled law that penal laws have to be precise, not broad. They have to be narrow. There's a matter of individual liberty. You cannot say that penal laws have to be broad to give the government wide-ranging powers. This is what perpetuates the wide abuse of power. And my last point, as I see my time is elapsed, is that Kedarnath Singh versus State of Bihar, which he placed heavy reliance on, in my submission, has erroneously not read down section 124A of SPC enough because they have retained the intention or the tendency test, which I think makes it mandatory to have Kedarnath Singh relooked and reevaluated by Constitution Bench. With that, I'm grateful for a patient hearing.
Thank you very much, Counsel.
Thank you, Aman. Thank you, Rohan. I now request the judges to give a general feedback on the proceedings, after which we can open the floor for questions. And I request all the members of the audience to raise any doubts or queries that you have by using the hand raise feature, or you can use the chat box with it. Judges?
Sure. Thanks, Karan. Ketan, do you want to go first, or shall I?
Go ahead. Yes.
Okay. All right. Thanks, Ketan. Okay. Hi, everyone. Good afternoon. So first things first, these two, Aman and Rohan, were amazing. They were far better than I have ever been. And you can just see in the manner in which they argue, their ability to just answer questions and the way they navigate their issues. It's brilliant. And honestly, it's artful, the way in which they both went about things. I'll get into a bit more in terms of specifics. So, every moot, I think you should have like an introduction at the beginning. Maybe when you have like your internal elims, you have like a bunch of rounds. So maybe the judges won't ask you for an introduction especially if you're arguing third or fourth in the room. But every time you are required to provide an introduction, it's key that it's succinct, it's to the point, and it's crisp. And Aman's introduction was everything. It was precise. It was everything that I wanted to know. Even if I hadn't read the moot problem coming in, I would have known everything that I needed to know. So it was packed full with information and was great, and didn't go any more than it should have. In general, both of them did really well when it came to answering questions. And Ruhan's in particular, I framed the question in a very weird, or maybe not even the best way. And Ruhan navigated the question so well. He took my question and just allocated it to a particular legal principle and used that legal principle to answer my question. That was brilliant. That's why I was saying it was artful. Another thing that he did, which was, I think, something that you do more maybe in a virtual moot, is where he said, like, I sense the question. I think that was with Keta use. That's really good. In a virtual moot, it's really difficult sometimes to, interrupt someone, to mess with their flow. So when you have the ability to do that, it's really nice. Both of them were really good with time management. They were mindful of how much time they had. Every time they needed additional time, they sought an extension, and every time they were going slightly overboard, they let us know that they were aware of that and they were wrapping up. So all of that was really good. And just a bit more on the general side of things, and this isn't necessarily to do with either Aman or Ruhan, but something that they illustrated really well is that they knew the basics of a moot really well. They knew the foundational law, they knew everything, even something that I didn't really think of because I didn't spend too much time on it. But Aman mentioned, I think, towards the end, that ultimately, if we decide anything in favor of the petitioner, it's to refer it to a constitution bench. We're not striking it down as unconstitutional. So that's something that shows good application, a good presence of mind, and that's really nice. Yeah, I think just one last point on a virtual moot, perhaps this is a really important point, is you should, I think both Aman and Ruhan's example is great here. They've placed the camera really well in front of them and you can see them bang in the center. Like mine's probably the worst one here of all the people that I can see because it's off-centered, it's at an angle. You should never have it that way. That's terrible for a moot, at least when you're arguing. So yeah, I think that's about it. Ketayun, if you want to go ahead.
So I think Yash has covered everything for the most part. Yes, Aman and Rohan were really good. And so the flow and the structure was something that you guys should look at. And specifically is they told us exactly what they were going to be arguing and they followed through with that. So that is something which was really good, especially the structure. And coming to the last part, which was the rebuttal. I think when you look at a rebuttal, this was something how a rebuttal should be like. For example, he took something that Ruhan argued, specifically what he used to answer questions, and he turned it over as well. So the only thing that you do in a rebuttal is you take what the opposite person's argued and you turn it on themselves, and that's how you leave your argument with a good point. in hand, and you basically ended by proving a point that you wanted to in the beginning as well. So that's something that I wanted to add. Other than that, questions were answered really well. And specifically for Ruhan, that one thing, the ambiguity point as well, I thought that was a little difficult for him anyways to have argued, but he took the other explanation and he went ahead with it, which was really good. So that's it.
Thank you. We can now take questions. Drishti, judges, would you like us to read out the questions from the chat box, or would you want them to unmute?
Anything works, I think. Whatever is like the easier way to go about.
All right. Audience,
All right.
if any of you have questions, you can raise your hand and then unmute and speak.
So one of the questions in the chat box is, how do we prep for a moot beyond the prompt that is given?
Should I go ahead?
Yeah, sure. Go ahead.
So you basically take the proposition, you give it a couple of good reads, then you identify your main issues. You pick one side first, and the first thing that you ideally do is you read the law. You understand what the statute says. Once you are fairly clear with what the law that you're looking at is and what are the comprehensive list of statutes that you should be looking at, you move on to any commentary, or if it's Indian law, you move on to case law. You finish your research there. Then you look at what propositions generally do is they end up picking a problem which has already been a lot argued about, or it is something that has come up in the news. It is maybe sub judice at that point. So you try and look up news articles and see what is happening, have people written on it. You look at research papers, and you basically ensure that from each side you have covered enough to prove your point and to lay down a structure of argument, basically answering the why. As long as you answer the why with every answer and you have something for yourself, you should be able to complete the entire research paradigm.
Yeah, I think Ketan's covered everything. Just something that's a bit more personal. I always, once I have the issues isolated, I will just pick up any commentary or multiple commentaries and I'll just read it back and forth multiple times, because I want to be familiar with everything before I even start looking for cases. Because, sometimes you're searching for cases, you'll maybe just find some, you won't find everything, but commentaries tend to be more exhaustive than your research would be, at least if you don't give it too much time. So yeah, and then of course, everything that Ketan has covered, even simple stuff like Googling stuff, that's really helpful, at least in the beginning. Not something that you want to cite while you're arguing, like like an article that you find, but definitely for your own understanding, for your comprehension.
And sorry, just one more thing, just specifically for your freshers moot, since you're given only one side, I would say also look at the other side. Don't just look at your side. See whatever judgments come from the other side as well, because those will probably be the questions that come for you. So just for that moot, because normally you will be arguing both sides, but for your freshers moot, please do research on both sides.
So another question is, when the prop says that laws are pari materia to the laws of India, this includes both the statute and the case law, correct?
Yep.
Participants, if you all have any more questions, you all can drop it in the chat box.
While we're waiting for just questions to come in, I had a couple of points that I think would be relevant if I were mooting again. And just wanted to let you guys know, especially at the fresher level. One thing that we tend to, at least when we're mooting, tend to complain about a little bit, at least I would, is we argue about the strength of our case. We'll say, the respondent side is too weak, the petitioner side is too weak, I've been given that side, it's not fair. And the truth is, everybody knows if there is an imbalance in the moot problem, everybody knows. So, and the best thing about a moot is, unlike a real hearing, the strength of your case isn't as important because what you're judged on is your advocacy. Also, the ability that your ability to help yourself with your own research and ultimately build up the strength of your case, that of course counts. But if there is an imbalance, everyone knows, the judges know it. So just bear that in mind. Yeah, that's it.
Just to have a prompt that the judges and mooters can answer, what would you be doing if you were a first-time mooter, and what would be the approach that you would have for a certain problem, considering it's a precious moot? The sources that you would rely on, the way you'd come up with your research.
So I would say, firstly, just read up on your absolute basics. If it's on constitutional law, your Article 14, 19, 21, read the main judgments on these points. Look at what everybody uses for the precious moot is Durga Das Basu. Just read the commentary for Durga Das Basu. Just see what your fundamentals are. Once you get that right, only then will you be able to really take your arguments forward. So if you get the principles right, like in this precious moot proposition also, we didn't argue this contention, but the first contention is maintainability of the writ petition. Now in the present case, there is a petitioner who is a NGO, and Article 19, if you see, says any citizen. So the maintainability ground would be raised on the fact that it's not a citizen. So once you get those basic fundamentals right, only then we'll be able to come up with counters for that. So that would be my suggestion. Just read the main landmark judgments, and of course, Yash, Ketan, and Ruhan will know far more than these.
I mean, very frankly, 100% rely on commentaries, rely on case laws. I think it's imperative. But the one thing, I mean, from a very personal viewpoint, that's always helped me is starting with like just random, like a Google search on just basic articles. Because frankly, the language gets toned down quite a lot in those. So at least when I was at least starting off in my first moot, the first thing I did was just literally a Google. I remember, so my first moot was barring the freshers, was on the Indian Stamp Act. I had just sat and Googled like random articles on criticism of the Indian Stamp Act and sat and read up on that prior to even like focusing that much on my proposition itself. So maybe y'all can give that a shot if it works well.
Yeah, and just adding to that is basically when you are reading things, it's very easy for things to like slip by. You might have read something that's pertinent, but you will not like, pinpoint it as pertinent at that point. Maybe at the very end, you'll come back and you'll be like, I've read something possibly about this and I can't really remember the answer. So as you go ahead, if it's like an online commentary, keep highlighting, make a note on Word, just, copy paste the link and keep it with you and say what it is for. In the end, maybe a day or two before the moot, when everyone really, starts putting their speeches to paper, it becomes very helpful, and you'll actually just go through all your citations. You'll know exactly what you're getting from. And citations become important in a moot, especially if it's a commentary. Note down where you're getting it from, and also see if that particular commentary is quoting another commentary. Sometimes those footnotes below become very helpful, and they open up like a plethora of other research options for you as well. And Google has everything. Even if you don't have access to the commentary, Google Books will provide it for you. You might not get the entire thing, but something relevant will pop up. So that's perfectly good.
Yeah, what Keta is suggesting is a major save. It saves your time significantly, especially if you are doing like, national, international modes where you have to draft mems. Just culling out stuff, your research into a Word doc in the very beginning itself, once you start researching, will save you a lot of time when you have to like eventually get to drafting a proper memorial. So yeah, that's a great suggestion, Keta.
Yeah, Vedika, you have a question?
Is this, am I audible? Is this good?
Yes, you are.
So I mean, as a fresher, I'm just trying to get a hang of what mooting is like. It's very different from debating, right? So even like getting a hold of the language and the, the format and everything. Specifically, I'm looking for like a good YouTube channel that I could refer to and start with, to just get familiarized with the entire thing. Is there something like y'all would suggest?
If you actually Google or go onto YouTube and search for some of the international moots, definitely their final rounds and all are uploaded. In fact, they used to be streamed as well live, and then they're still uploaded there. I'm sure that will be also the case for some of the national moots that we have, at least the bigger ones. And even if not YouTube, I don't know if the MCA allows this, or maybe for certain moots, maybe like the finals of your larger moots, you should definitely go and attend, because that's experiential learning that goes much further than reading about how to moot. So yeah, that's a great suggestion.
And what should I expect from my first moot? I do not, I mean, the picture right now in front of me is very typical language and fluidity. I do not expect that from myself, as of yet, at least from my first moot. So what am I looking at?
So I think for the fluidity, it comes with practice, and the more you learn to speak, it comes over a period of time. I think the best thing you can do is write a speech down and then just go through it multiple times, clear out all the loopholes there, and then sit and read it. When you're actually arguing, ensure that it is not a speech, say exactly word for word what you're going to be arguing. Ensure there are pointers. And I think mentally, as long as you're clear in what you're supposed to be arguing, what it is that you're asking for from the tribunal, and you've preempted certain questions, right? Like I think Aman mentioned saying research what the respondent or your opponent's going to be arguing as well. To an extent, you will know where the loopholes are, and that's what the judges are always going to ask you. So you will have some kind of an idea on what is your answer going to be. And then see, you can stutter, right? Nobody is going to, at least in your freshers mode, going to yell at you or going to, mark you down for that. Just speak slowly. If you feel like you're wavering, it's okay to take a 10-second pause. Nobody is again going to, take that badly. You've been asked a question, you don't know the answer. Pause for 10 seconds, collate something in your head, and then respond.
Noted. Thank you so much.
Welcome. Also, debate is very quick. I know, like people speak really fast. That's something that you should not be doing in a moot. Moot speaking is a lot more formal. So just be like, cohesive of the language and the formality, and go very slow, as slow as possible. That's something you can do like best for yourself.
Yeah. Thanks.
So Priya has asked, what should be the ideal ratio between citing case laws and sticking to facts in the arguments?
Okay, I can take this one. It really depends on your moot problem. Especially if in a case like this that we've had today, where the law is fairly well settled, it's not a case where you're bringing about certain case laws that are completely new that nobody knows about. Everybody knows what 14, 19, 21 is. At least the judges that you will have, they'll know. So I would say in such a case, you would need bare minimum. It's all about how you're using the facts in the moot problem and how you're maybe twisting the facts in your favor. And interpreting it again in your favor. That's what really counts. Maybe in another moot problem where your research is really instrumental, maybe you found a case that completely changes, or a couple of cases that completely changes the argument that tied in your favor, then rely more on case laws. So yeah, it varies, it's dynamic.
And I would also add that just once or twice during your speech, just take the judges to the moot proposition, because in many moots, there are some marks that are allotted to reference to the moot proposition. So in that case, that can be your way of sticking to the facts by taking them to the paragraph, telling them that this happened and this is why I'm placing my argument. So that may help in certain cases.
And just adding there, something that Professor Daswani told us, like in our very first, like the freshers moot, is you have the law. Everyone's read the law at some point. If you've done basic research, learn to wrap the fact around the law and get the most of the side that you've been dealt with. That way, your law stands straight, but you've ensured, to read your facts, interpret them in a particular way that's going to be helpful for you. And that will only come if you really intensely scrutinize the moot proposition.
Great. So to answer Priyanka's question, the freshers is 1v1. So it's one petition and one respondent, and there will be no teams. Disha's question is for citations and reference to case laws. There's a possibility that certain things in a judgment go against your contention. How would you counter that?
I mean, I guess I can take this one. So essentially, the way I've always seen it is, and this is again a very personal thing, both in terms of the arguments you make as well as the judgments you cite, say what helps you the most first. Ideally, whatever your strongest hitting point is, whatever your strongest hitting case is, ideally say that first. If there is a point within a particular case that you feel is going to work against you in terms of whether it's a factual distinction, whether it's maybe some sort of argument raised by the opposing counsel, whatever it may be, maybe try and cover it up as much as you can, or try and distinguish your specific proposition facts from what happened in that case. That would be my suggestion, ideally. And I mean, even this is an example, like Aman's strongest point over here, in my opinion, was Article 14, which also makes it my weakest point, ideally, which is why he brought it up first. I dealt with it or tried to deal with it last as far as possible. So I think something like that you can maybe try and employ. Maybe even in terms of cases, you can do a similar thing.
My personal thing with case laws is, especially in topics like constitutionality, there are a lot of constitutional law judgments on each and every point. So if you get a particular judgment which has something great in your favor, but then 3 paragraphs below, it has something that can be easily interpreted against you, my personal practice is to avoid that judgment as a whole. You will get many judgments in constitutional law which say what you want. Of course, if it's the only one, you have no choice, then try and distinguish it. But as far as possible, if there are contradictory views in the same judgment, try and avoid that judgment, because it can look bad if they come and they say just 3 paras below, you have not read it, but it says something totally opposite. So that's my completely personal opinion about this.
Great. So the next question is, how should we ideally try to structure our speeches as arguments for freshers?
So I think I can take this. So I think IRAC is basically the method that I used to personally rely on while at least drafting the first cut of my arguments. Is you give a little bit of your introduction, you introduce the issue that it is that you're going to be arguing about, then you state the rule, which would be either the statute, or if you're looking at a convention, then that. Then you further go on and you give an analysis along with the fact. So then you take the judge to the fact which is in your favor, or even if it is against, or you're trying to distinguish yourself from what the opposite person said and why it would not apply to you. You conclude with an analysis of the two. That is, you take the rule, you explain to the judge why it is that what you're saying matters, or why they on what you're asking for, and then you give a small conclusion saying this is exactly why I'm asking.
Great. So the next question is, how is the approach for researching and arguing in a moot different from that of debates and months?
Okay, I can just quickly address it. So the distinction in the beginning, when you're starting out, you'll not be able to figure it out. But once you, I guess, do all of these a little bit more, you'll figure out that there is actually a vast difference. So obviously in debates, you don't really have much to do in terms of research. More often than not, you'll be given like what you're arguing, you'll be given it almost on the day or immediately then and there right before you go ahead. Whereas with moot, sometimes you'll have months and months to prepare. I don't know if that's the case with months. Maybe you'll have with MUNs, you'll have maybe just a couple of weeks or maybe just a month or two. But I have had moots where you had almost 9 to 10 months to prepare. And that's because you have a lot to research upon. And larger moots, you tend to also have much more time that you have to argue for. So when it comes to actually putting across your arguments, obviously MUNs are totally different. You have to you obviously have a completely different format. It's not adversarial as it is with debates and with moots. But in debates, it's very different in the sense that you're making, it's a bit more pompous. You're trying to make your point across a bit more. You're trying to be, as I think Keta even pointed out, it's a bit more fast paced. It's all about just trying to get a one up on the other side. But when it comes to moots, and maybe this is just the lawyer in me now, I think it's a little bit more civilized. I think it's a little bit more, I understand what my learned friend on the other side is saying. And I disagree with him for XYZ reasons. I think, therefore, a little bit more civilized, but the difference in the approach is something that you'll figure out once you start doing it, and you'll understand that it's a big, big difference.
Is there anything else the other judges and would like to add to this?
No, I think he said it all.
Just another prompt. When I go back to the first freshers that I had, there were 2 things that really stuck out to me. The first was that the judges were constantly asking me questions. So that was something that I was not expecting. And the second was that since there's a time constraint, So I had to change my arguments for that. So what would your perspective be to go about such a situation?
I mean, see, in terms of at least the questions, the judges will ask you questions. They're essentially there to test you, right? And that's where you basically get tested. Because in terms of the freshers moot, at least I think you guys must be at least minimum having 2 weeks to prepare. So the assumption is that you know your speech well enough and you will be bringing up your strong points. But questioning is where you really get tested because they'll ask you obviously the other side's strongest points. The manner in which I try and adopt it is be as calm as you can and answer it as briefly as you can and try and not invite follow-ups. Because that's something that, like Karan also mentioned, it tends to eat into your time and you're anyways short on time. Also, like I assume you guys also have at least maybe 2 or 3 contentions potentially to argue for your freshers. So time allocation in between contentions is also important. Try and maintain that because, for example, in Aman and I's case, the second contention, which deals with the golden triangle, is by far the most important one in terms of your case. Whereas maybe maintainability in the third one, a 1 minute argument would probably suffice. So maybe I can do something along those lines when you all are making your speeches.
And also when it comes to judges' questions, I mean, today, Yash and Ketayun were very, very, I mean, I would say good judges. They gave us few questions and they heard us out. But there are also some judges who you will encounter who just keep bombarding you with questions and just constantly try to trap you. So like Ruhan said, in that sense, and I'm not trying to scare anybody, but in that sense, just maintain your composure because what they're looking for is just to see whether you maintain your composure or no. When they ask you questions. And like Yash said in his feedback, and I totally agree, taking that question and molding it into one of the arguments, which you anyway planned on delivering later, would be the best when it comes to answering questions and saving your time, because then you're doing both at once.
And just like a tiny thing, like expect sometimes the judges end up asking you 2 or 3 questions instead of, just sticking to one point, and you will be expected to answer all 3 of them. Mentally just give a note and follow the 1 2 3 pattern that they've done and just move ahead. Like as these guys said, keep it as brief as possible. If there's a yes no answer, don't go into a long explanation. If he's just saying if you agree or not, stick to the yes no, move ahead.
So
Yash, sorry.
yeah, would you like to add anything to that?
No, I think that they covered it well.
All right. So the last question is, if questioning with one contention gets stretched out, how are we supposed to navigate through the process and put across the rest of our points as well?
So I think if you know that there is probably one contention which is going to have, for example, here 2, right? 1 and 2, you would end up covering, I think 4.5, at least 5 or 6 minutes, and you barely have any time for the last one. Ideally, you prepare like a 2-line, 3-line conclusion with you, keep it in your paragraph notes. At least that's what I used to do. When I know that I might always with practice know I never have time for the last one, you just have a tiny conclusion ready, which you can read out, which proves your point and is enough to, like put across what it is that you're arguing without going into extreme detail.
Understood. Seeing that there are no other questions, on a concluding note, would you like to give a very, okay, there's another question. Yeah, it's the same proposition that we'll be following, right? Would the 4 of you be willing to just give a small concluding note on how they should approach the freshers, since they have a couple of weeks towards the freshers now? Something that they should keep in mind before going into the arguments.
Sure. I mean, I'll just give like a couple of points. I mean, you've already heard a lot about how you should research and in fact, even how you should argue from both Aman and Ruhan. But one thing you probably aren't prepared for is to fail. You should be excited to fail. I know this sounds ridiculous, but you should expect to be nervous. You should expect to sweat. You should expect to be completely jittery. And you should probably, I think freshers is statistically the most competitive mood you'll ever have, given the number of participants that'll be there. And it's almost likely that you're not going to get anything, you're not going to be successful in the mood. So it's an experience and you're supposed to learn from it and take from it and then put it into any other mood that you do afterwards. So don't think of it as an achievement. If you do well, of course, it's great, but it's all part of the learning process.
And like I would, now that I look back, we were all very, very bad in our freshers moot. And, in hindsight, we really look back at sometimes and we see the arguments we make. And honestly, at that point, with whatever preparation you do, it's only with the intention of the fact that I learned my basics. And then 2 years later, when I look back, I'll be able to say that because of that, my foundations at least got set. And now I can look back and laugh at whatever arguments I made. So don't think that you have to give some very learned arguments or some very erudite arguments, because we were all talking in the air in our freshers moot, just hoping the judges would not come down heavily on us. So don't go into it with any stress.
And don't let it dishearten you. Like I saw that with a lot of people in my freshers moot, who after a point, after being heavily questioned by judges, just stopped mooting for a couple of years. They said, no, we can't handle this. It's okay. So I think the thing is to, be mentally prepared for the question, enjoy that conversation with the judge. That's going to put you as much ease as would be possible in that particular scenario. Don't worry, don't like I've heard this thing, like, the judge hated me, I was so bad. No, they're questioning you because they just want to know how much you've done or how much you've prepared. And a lot of questions sometimes are a good thing. That means they're enjoying your argument. So don't be disheartened, don't worry, don't struggle. That's perfectly all right.
Very honestly, I think these guys have pretty much covered at least the benefits of mooting very, very well. The only thing I'll just add is that, in at least my experience, mooting has taught me like more about the law than pretty much any other thing I've done in college, at least from a practical viewpoint. So ideally, if you do this and do it throughout your entire college career, it does help you later on in life as well. So I think that's just something to keep in mind. So obviously don't get disheartened and try and do it as much as you can.
All right. With that, we come to the end of this session. On behalf of the Moot Association, I would again like to thank Mr. Shiralkar and Ms. Mistry for sparing time and being with us this evening, and also Aman and Rohan for demonstrating how Moot functions. And I'm sure that this was of great help to the audience and freshers. Thank you so much.
Thank you.
Thank you.
Thank you.